Good morning, everyone, and welcome to Governmental Affairs. We've got a few items on the docket. Everybody's bill is the most important right before crossover. All right, so obviously some of the authors of the bill chuckling out there disagree, and therefore they won't be called. Let's start with, is Chairman Martin here?
Yes, sir. You asked me if I was here. I didn't know if you wanted me to come up. Make sure I'm following
I just want to make sure you were here.
Yes, sir. Make sure I'm following instructions.
Roll call. House Bill 349, Chairman Chuck Martin, and if you'll start us off and let us know which LC we're working off of, I'd appreciate it.
Yes, sir. Well, I have a substitute to 349 that is the substitute that went through subcommittee, so it's the same bill. We're working off LC 40.
Hold on real quick. For members of the committee, and that's a good point, Chairman, and I should have mentioned it, all of these have been scrubbed with the exception of one in the appropriate subcommittees and should be clean and ready to go.
Yes, sir. Just to be clear, this is a substitute, but it is the same substitute that the subcommittee heard. It is LC 1161 ERS, LC 441161 ERS. Mr. Chairman, what we're to say, and you also should have in your packet a letter from the city of Emerson. What we have is a situation where the current redevelopment powers law allows for a county to use their redevelopment powers in the unincorporated area. What we seek to do here is allow them to do so within the corporate limits of the constitutional limits of the county, which would be within the city limits as well. And in order to protect the cities, we've installed on lines 13 through 16 the language that says, in case of a county or redevelopment agency, such term may include any, having trouble reading this morning. One contact fell out. Also include, always glad to be in front of you, Chairman Reinders. Such term may also include part or all of the territory within the county, including the corporate limits of the municipality, when, and this is the important part, when authorized by a resolution of the governing authority of such municipality. So basically we have a situation here where a redevelopment authority of the county wants to go inside the city, because in this case the city of Emerson does not have redevelopment powers and is not interested in doing that. So this is not, if you're familiar with the TAD, Redevelopment Authority, this does not require the city of Emerson to pledge their increment. So this doesn't bother the city of Emerson. And in this particular case, Mr. Chairman, this is a statewide bill, so we put that protection in should it go forward. So basically this is completely permissive. We hear prescriptive and permissive down here a lot, Mr. Chairman, but this is a permissive thing. This allows it to be done, but does not require a city to participate. And with that, I'd be glad to stand for questions.
All right, let me just make sure I understand.
Yes, sir.
Can that development authority impose their will on that city, or does the city has to pass the resolution asking?
Well, asking or agreeing to.
Okay.
They cannot. I don't know if it's a chicken or the egg, but
Right.
They cannot go within the corporate limits of a city without the city passing a resolution. Yes, sir.
Very good. Questions from members of the committee, number 25. Who we got there? Chairman Fleming.
Thank you, Mr. Chairman. Is this on a case-by-case basis? If I want to develop a solar farm and the city says you can come in here and do that, does that mean that next week they can come in and develop a battery factory? Is it on a case-by-case basis, or once you open the doors, it stay open the whole time?
My understanding is it was intended to be on a case-by-case basis. I see the gentleman's point right now that the language was put together by our friends at GMA.
Which means they should have caught it.
Well, my suspicion is that if you give authority, Mr. Chairman, through a resolution, you can withdraw authority through a resolution, because
I would suspect that to be the same. We can
maybe later on
we can look forward. I know that is the intent. No one is trying to sneak up.
Maybe if you could find the answer to the questions.
Chairman Fleming. I'm going to defer to your legal wisdom, is there a fix in this that would prohibit exactly what you're talking about, or you have confidence that as we move forward that no one will misinterpret legislative intent?
Well, what I think we can do is that if the chairman, Martin, will just simply ask that question for me, we could consider tinkering with it later if we need to. I'm fine with it moving ahead now.
And if I can, just to further that, to be clear, nothing in this takes a city's zoning powers away.
Sure.
So even if one would construe this to say that you could have a redevelopment process inside, once you did it until you revoked it, it would still have to have the city's concurrence, because if they didn't zone in your example, sir, the battery factory, it could not be built.
If we were a week ago, Mr. Chairman, I'd ask to wait and answer that question, but given where we are, let's move ahead, and the chairman will get that answer to us, and we'll adjust as needed later on.
You understand the intent of the
Absolutely, and
committee is not to leave it open for any other thing?
No, absolutely, and I don't think that's.
And if that interpretation is there in any way, you promise this committee you'll get it fixed?
We'll fix, absolutely. I
Thank
mean,
you.
there's no wish here for the redevelopment authority or the county to impose their will on a city and state.
Thank you so much. Any other questions from members of the committee? This time, the chair will entertain a motion.
Do pass.
Got a motion do pass and
By
a
committee
second. Any further
substitute.
discussion? All those in favor, please signify by saying aye.
Aye.
Opposed, like sign.
Thank you, Mr. Chairman.
Thank you. Chairwoman Silcox, House Bill 388. Good morning.
Good morning. Thank you, Mr. Chairman. I do not have the correct LC number. I tried to print it off on the website, but I gave your assistant the ones and twos yesterday, so I know y'all have it. Yes, ma'am. This is LC 289285 ERS, and this is a bill that's brought as part of the City of Atlanta's package, legislative package, to allow for impact fees to be used either in whole or in part to basically be taken away or exempt to allow for the development of affordable housing. And we had a change down, the Chairman Powell asked for the change down at lines.
Which Chairman Powell on this committee?
Chairman Jay Powell.
Okay. Little
Asked-
bitty rules, Chairman.
Yes, sir. Asked for the change down at lines 19 through 21, and I think this clarifies that section substantially because it does say, provided if a development project creates affordable housing and meets the requirements, then a municipal or a county development impact fee ordinance may waive the requirements. So I do think that clarifies that section.
And notice for members that is a may and not a shall.
Yes, sir.
Questions from members of the committee? This time I'll entertain a motion. Got a motion to pass. Do I hear a second? Several seconds. Further discussion? All those in favor, please signify by saying aye. Those opposed, like sign. Thank you.
Thanks, sir.
Representative John Carson, House Bill 466 through 68.
Thank you, Mr. Chairman, members of the committee. I bring before you House Bill 466, 67, 68. And before I start, I want to thank Representative Earhart, the better-looking Representative Earhart, Jenny Earhart, for standing in for me last week while I was out of town. You may require earlier this session, the House gave favorable passage to two nonpartisan bills for Cobb County. That was for magistrate court and probate court. And there would have been four in that total package based on local officer requests, but I was informed by legislative counsel that that was not technically possible for the clerk of Superior Court and clerk of State Court that have requested the same nonpartisan treatment for their office as well. So that's the genesis of 466.
All
So,
right.
Mr.
All right. Any questions as it relates to 466? What's your number, please? 11. Representative Shannon.
Okay, now it's working. In reference to bills 466 through 68, it's more of a comment. All the bills that you've brought before that have to do with Cobb County, I've been told over and over again by other folks in the delegation that these bills were not properly vetted. They weren't really talked about within the delegation. And so I don't want to see governmental affairs turn into a drama ground for Cobb County. And that's what I've been told about all these bills. And so for that reason, I'll be voting no.
Thank you so much. Are you familiar with Rule 50?
What is Rule 50?
All right, please proceed.
With Rule 50 or keep going?
No.
Okay.
Any other questions?
So basically, 466, Mr. Chairman, this legislation authorizes, but I want to be clear, it does not mandate. It authorizes local delegations to have the option of changing state and superior court clerks to nonpartisan positions. Based on what the feedback was from Legislative Council, clerks are not on the list of eligible offices to be made partisan by local delegations because they are not interpreted to be judicial offices. Even though they are part of the judiciary system, they're judicial officers.
All right, any other questions as it relates to House Bill 466? Number 15.
Thank you, Mr. Chair. Though they are not authorized to go through local delegation, were all the members of your Cobb County delegation on board with these specific bills?
No, they were not.
Can you share with us, Mr. Chair, if I may further?
You may.
Thank you. Are you willing to share with us what the breakdown was between your delegation and perhaps the reasons why there was some dissent?
Representative Wynn, if I may ask, why is that relevant since this is a general bill pursuant to Rule 50?
Oh, well, I was just asking in respect to the set of bills, particularly because I know within my own delegation, it becomes challenging to make decisions about other people's without fully understanding what's happening. So I just want to make sure that I have a full understanding. Thank you.
I don't really, this has been talked about among our delegation. There is some dissent. There is some agreement. Other than that, I don't have much of a response other than that. And again, this is a general bill. 466, and frankly, all three of them.
Representative Wynn, further questions? No, thank you. Any other questions? This time the chair will entertain a motion. Got a motion to pass. Do I hear a second? All those in favor, please signify by saying aye. Aye. Those opposed? No. Let me see the hands on the noes. Representative Brunel, is that a no? Thank you. House Bill 466 passes. Next, House Bill 467.
Thank you for that, Mr. Chairman, members of the committee. Once 466 goes into place, then House Bill 467. All this does is basically take the clerk of Superior Court of Cobb County to make her position a nonpartisan position, as per her letter of request, which should be in your packets, I believe. If I may, Mr. Chairman, this was run as with a local legislation ad, but Mr. Chairman knows that of which he speaks. Rule 50 requires that I introduce and run this through the House as a general bill.
Thank you so much. Any questions as it relates to House Bill 467? At this time, the chair will entertain a motion. Motion to pass. Got a motion to pass, second? Further discussion? All those in favor signify by saying aye. Aye. Those opposed, like sign. No. House Bill 467 passes. House Bill 468, Representative Carson.
Same issue. This is the taking the clerk of State Court of Cobb County to be nonpartisan as per her request. Local ad was run, affidavit was signed, and same drill, Mr. Chairman.
Thank you so much. Pursuant to Rule 50, it's not local legislation, therefore it doesn't need the signatures. At this time, the chair will entertain a motion. Got a motion to pass. Second? Any further discussion? All those in favor, please signify by saying aye. Opposed, like sign. Ayes clearly have it. Is your work here done, Representative Carson?
Except for the one bill that you and I talked about yesterday.
I'm going to hold off on that one.
Okay.
Thank you so much. Did, generically speaking, did we get that resolved to your satisfaction as it relates to other parties? If we didn't, did you get a thumbs up?
The one in sub that was discussed
Yes.
previously? Not as of yet.
We'll keep it alive then until while those discussions continue.
Okay, thank you, Mr. Chairman.
Thank you. Representative Mark Newton. Can you kind of see the seniority thing working here?
I'm always learning. I told you, it's like a multi-year residency. I'm getting better. I'm just know enough to be dangerous. I bring before you, Mr. Chairman and members of the committee, House Bill 315, passed through the subcommittee. This is a bill that deals with local governments and municipalities that are spending taxpayer money through either authorities or through their own items. This is a transparency bill that deals with consultants. When local governments need to hire someone to help them prepare a bid or a bid package or an RFP, this bill just requires transparency. This bill requires transparency if there are any financial relationships with any of the individuals or entities bidding on the project. So it's really just a disclosure. This bill did pass last year nearly unanimously through both committee, the House, and the Senate side, and was eventually vetoed by the government because there seemed to be a loophole that allowed disclosure even with economic development activities. So to clean that up, we've changed the language in a couple of ways in this bill from what passed both chambers last year. We've excluded, if you see on line 47, I'm dealing with LC 289221S. If you look on line 47, there's some exclusions, economic development activities under Article 4 of Chapter 18 of Title 50. Additionally, an attorney is already, their disclosures are covered by the bar, and therefore what they can and cannot keep confidential or disclose has some caveats, so that we have that represented here. And in addition, at the appropriate time, there is an amendment that adds a development authority group as well. This actually, the one other thing I guess it does compared to the bill that did pass last year was this actually allows and recognizes that in a lot of our smaller jurisdictions, there's not a lot of depth when it comes to the number of individuals or people who can give advice on bid packages and RFPs. And so it actually doesn't preclude them from having a relationship with one of the bidders. It just says they have to disclose it. The previous version kind of excluded you if you had a conflict of interest of a material financial arrangement with one of the bidders, you were excluded. This actually just requires transparency. So it's a bill that I think really recognizes that when taxpayer money is being spent by any government entity that's being collected and spent, there should come with it a degree of transparency, and that should apply to someone giving advice to the county in the form of an RFP package or a bid package as well. So it's just it's a transparency bill that I think would take us a good step forward. There's not a lot of documentation, since right now this disclosure is not required. You could have individuals or companies or entities that are helping prepare a package that have a relationship with one of the bidders, but we wouldn't know it. It just becomes background information, suspicion. This will help clarify that and help bring a good bit of transparency.
Questions from members of the committee, House Bill 315? This time I'll entertain a motion. Got a motion to pass. Do I have a second? Further discussion?
At this time, I would like, if with the chairman's approval, amendment AM 281698 that I've discussed with Representative Williams and others. This is it simply clarifies a couple of items that were in the bill that passed through subcommittee. on line 3 of the amendment, you'll see it's a consultant's an individual or company that is paid or engaged to develop these specifications. Usually sometimes there's a very large project and a small piece of it is helping prepare the bid. This just captures that when someone is paid or engaged to develop specifications or to serve in a consultative role during the RFP process. Second change was just a clarification on line 35 of the bill. There was disclosure of past, present, or prospective engagements, and obviously we added the word known prospective engagements.
I love you, but so that going to the first part of the amendment, consultant means to serve in a consultative role.
Yes, sir. Using the word in the definition. Huh? My English teacher would be disappointed.
Yeah. So would others.
Fair enough.
Any further discussion on the amendment? Move to pass on the amendment. Do I have a second? Second. Any discussion on the amendment? All those in favor of the amendment, please signify by saying aye. Aye. Those opposed, like sign. All right, now we've got a motion for a first and a second on the passing with the amendment. Any further discussion on that? All those in favor, please signify by saying aye. Aye. Those opposed, like sign.
Thank you, Mr. Chairman.
Representative Wiedenauer, House Bill 392.
Morning, Mr. Chairman.
Good
members
morning.
of the committee. I come before you, House Bill 392. It's LC 411823. There's been no substitutions. Same bill as the subcommittee saw. This is came from a request from the Georgia Department of Public Safety to add the Board of Public Safety onto the list of boards and commissions that permits them to provide an expense allowance and travel cost reimbursement for the members of that board as they meet once a month across the state of Georgia. It is approximately a $30,000 cost that they are going to assume into their own existing budget, so net zero to the state. Entertain any questions?
Any questions from members of the committee? This time the chair will entertain a motion.
Motion to pass.
Got a motion to pass. Do I hear a second? Any discussion? All those in favor of House Bill 392, please signify by saying aye. Aye. Those opposed, like sign.
Thank you,
Good
sir.
job. Thank you. And finally, Representative Brunel, and this is one that we did not scrub in a subcommittee. House Bill 34. You understand the no vote early wasn't local legislation that you had?
Yes.
Okay.
Good morning. Thank
Good
you,
morning.
Mr. Chairman, for allowing me to present this bill. It started off as HB 34. It is asking that a change be made on development authorities because currently they cannot be removed. So it's asking that the requirements for appointees will be residents or licensed business owners paying or add valorian taxes on real or personal property within the county or municipality, corporation in which the authority is created, and the removal of members or directors will have due process prior to removal. The cause will include but are not limited to neglect of duties, incompetency, failure to meet the residency requirements, or unethical or dishonorable conduct likely to deceive, defraud, or harm the public, county, or municipalities. The member director will be notified for the reasons at least 30 days prior. And I did talk to ACCG, and they were okay with the bill.
We're going to get to them. What is the back, page 2?
Okay.
Anything that we need to know about?
Yes, on back of page 2, we have an amendment. The amendment is on for, starts at line 18. The
I'm
amendment-
sorry,
that
before
the
we
one
get
you
to the
want?
amendment, the
Oh.
back page of your bill. Starting on line 27.
Okay, what are you asking me?
Well, I'm sorry, you went over the first part. I didn't know, for the benefit of the members of the committee, since we didn't do this in sub,
Oh,
if you
okay.
can tell us what page 2 does.
Okay, what page 2 does is it gives the notices. We changed it so that they have a 30-day notice. That way, the individual has enough time to, we give them a notice, and then they have enough time to respond if they need an attorney or, somebody to represent them. And so then after that, then, they would be, the vote will come in whether they would be removed.
Chairman Fleming, if I may ask, is 30 days the standard in those kind of notices? That's pretty standard. Okay, thank you. All right, any questions for Representative Brunel? 17.
Yep. Thank you,
Scott
Mr.
Turner,
Chairman.
Representative Turner.
Thank you. And Representative, thank you for the bill. And if you can't answer this, I'm sorry. Maybe one of the lawyers here can. The line 20, it says failure to meet residency requirements set forth in paragraph 1. And I go back up to paragraph 1, and it says they should be residents or licensed business owners paying ad valorem taxes. So are we creating a conflict here? If there's residency requirements and you don't actually have to be a resident to be on the authority?
I think the sub will clear that part up. It should.
Chairman Fleming.
Thank you, Mr. Chairman. I was trying to absorb Representative Turner's question, and I think it's fairly common in these development authorities to say that you either live there or you own a business there, with the idea that you may own a business in downtown, but your home may be 10 miles outside in the county. So it's okay to use that type of language there, and I don't think you're creating a conflict, as you mentioned. That's my opinion.
Representative Jones.
Oh, I apologize, Chair. I just wanted to say that I concur with Chairman Fleming. I think it's clear.
Thank you.
I do.
All right. Chairman Fleming.
Thank you, Mr. Chairman. When I first read this bill, I understood that you need to remove someone on development authority if they are, if they've done something improper, basically. But there is the law does anticipate some distinction and differences between the city council and the authority, the development authority. And I think the purpose there is because we give those development authorities much more ability to do things than local governments can. In other words, local governments can't buy and sell land in certain situations. Development authorities can do that easier because they're trying to bring a business in. So the idea was that there's some separation between the two, and the council doesn't have control over the development authority except by appointment powers. What you're doing now is you're giving the council the ability to remove somebody that is a bad actor, which I think is fine. We want to get rid of people like that. But we don't want to get rid of them just because you disagreed with their decision. If you disagree with which piece of land they bought and you wanted to remove them, well, that would be almost like the council having complete control over it and going through the back door to do something they couldn't do through the front door, if that makes sense to you. So my attention is drawn to the word incompetence on line 5 of the amendment and the word harm on line 22.
Okay.
So if
If you don't mind, let's when we get into the amendment, let's discuss that at that
yes,
time.
Sir. Yes, sir, Mr. Chairman, that's fine.
Just in terms of our posture. Any questions as it relates to the base of the bill? At this point, I'll entertain a motion.
Do pass.
Got a motion, do pass. Do I hear a second? All right. Further discussion.
Mr. Chairman.
You want,
Representative Fleming. Real quick, Chairman Fleming, at this time you want to reference your amendment?
Yes.
Please
okay.
proceed.
All right, the amendment is AM 450022ER, and it says any director may be removed for cause by governing authority of the county or municipality for which the authority is created, which shall include but shall not be limited to neglect of duties, incompetence, failure to meet requirements set forth in paragraph.
Chairman Fleming.
Mr. Chairman, as I was discussing, thank you, as I was discussing earlier, I want them to remove someone who has done something bad, but not just because they disagree with them in the decision they make. And I fear that incompetence gets a little close to that, because I may think you're incompetent because you bought piece of property A rather than piece of property B. So at the appropriate time, I would move that we take that word incompetence out, and then I'm going to also take out the word harm on line 22. So there's a due pass, I believe, Mr. Chairman. If someone needs to make due pass on the amendment, I'll do that, and then
You're going to want to amend the amended version.
you can amend the amendment once.
Right.
Yes, sir.
All right. Representative Williamson.
Yes, I just got a question. Yes. So thank you, Mr. Chairman. Just a quick question, that sort of same vein. The word "for cause," and I guess if you don't mind, I could maybe direct it to Chairman Fleming or one of the other attorneys here. Is "for cause" defined in Georgia code?
It is defined in Georgia code and or case law, and the general definition is you did something you really shouldn't have done.
Okay.
But there's a lot of cases that lay out what that is, and when you say just incompetence, that gets in close to the area of I disagree with you, rather than you've really done something bad. To put it in common parlance.
Thank you.
I think
Representative Jones.
Thank you, Chairman Reinders. Chairman Fleming, I just want to be clear. You're asking on 22 to take out the word harm?
That'll be my second amendment. Yes, sir.
So
Right.
then we're speaking to "or the public"?
That would be that you would if your conduct, it would read, if your conduct likely to deceive or defraud
Or the public.
That's what I'm getting at. I think we're missing.
Well,
Strike or, take or out.
the words deceive, defraud, and harm describe what you can't do to the public, county, or municipality. So if we just say, if you deceive or defraud
Right.
the public, county, municipality, if you take out the one harm, because harm could be, I think you bought the wrong piece of land.
Correct.
Deceiving or defrauding is much stronger. You have to have really done something wrong. Do you see my point?
No, I absolutely do. So we're going to insert "or" in between deceive and fraud.
And
to defraud, and then go right to the public.
That's right.
Right.
Well, you'll take out the words or harm.
Right, we're going to take out "or harm" and then insert the word "or" between deceive and defraud and take out the comma?
That's correct.
Right.
That would be my amendment when we get to that portion of the bill.
Okay.
I was just trying to understand. Thank you.
Yes, sir.
All right, let's make sure we check the posture. We have an amendment in front of us, AM 45022ER, and Chairman Fleming's point is that you're fine with this particular amendment?
Yeah, I would move that we amend the amendment by, Mr. Chairman, if you would allow me, by removing the word incompetence, removing the two commas before and after it, and instead inserting the word or.
Does the author of the bill object?
No, that's
Does that
fine.
meet the guidelines that you wanted?
Yes, that's fine.
All right, any further discussion? Then, well, we've got I want a motion on Fleming's amendment to the amendment. Second. So we're removing incompetence in the two commas, one in front of them and behind it.
And inserting the word or in its place.
All right. Now let's go back to the amendment.
Want to vote on that one,
Yes, first.
on the amendment to the amendment?
Yes. All in favor of the amendment to the amendment signify by saying aye.
Aye.
Those opposed? Now, the amendment. All in favor signify by saying aye.
Aye.
Those opposed, like sign. All right. Any other amendments?
Yes, Mr. Chairman. On line 21, I would remove the commas before defraud and after defraud and insert the word or. And at the same time, remove the words on line 22, or harm.
Okay, let's go back to line 21.
Yes, sir. On line 21, my amendment would be two parts, that we remove the commas before and after the word defraud, remove the word defraud, and insert in its place the word or. And then on line 22, remove the words or harm. So it would read, of this subsection, or unethical or dishonorable conduct likely to deceive or defraud the public, county, or municipality.
Legislative Council, you've got that? All right, we've got an amendment there. Is the author good with it?
Yes.
I will enter, is that a motion?
Yes.
Do I have a second?
Second.
Any further discussion? All those in favor, please signify by saying aye.
Aye.
Those opposed, like sign. Any further amendments? Seeing none, now we have the House Bill 34 as amended. All those in favor, please signify by saying aye.
Aye.
Those opposed, like sign. Ayes have it.
Thank you.
Do we have somebody else that wanted to? No, okay. For the members of the committee, we did this unusual meeting at 8 a.m. on Tuesday, with tomorrow being an open day for crossover, and we don't know what may come to us late, so I just wanted to leave that time frame open. Knock on wood, hopefully we won't have any hearings for tomorrow, but just a friendly reminder that that's possible. This time we're adjourned. Thank you.